This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why the duty to defend is exceptionally broad and how the eight corners rule will strike again whenever an insured seeks defense to a claim where the insurer believes there is no duty owed. M.I. Homes of Chicago, LLC, appealed from the Circuit Court's entry of summary judgment in favor of Acuity, a mutual insurance company. The Circuit Court found that Acuity had no duty to defend M.I. Homes in an underlying lawsuit stemming from damages caused by the allegedly defective construction work of one of M.I. Homes' subcontractors, because the complaint in that case did not allege property damage caused by an occurrence. In Acuity, a mutual insurance company versus M.I. Homes of Chicago, LLC, et al., a September 9, 2022 decision of the Court of Appeal of Illinois, the Court of Appeals resolved the dispute. The Townhome's Owners Association sued for breach of contract and the implied warranty of habitability against M.I. Homes as the successor developer-seller of the townhomes, and M.I. Homes asked Acuity to defend it in that underlying lawsuit as the additional insured on a policy Acuity had issued to one of its subcontractors, H&R Exteriors, Inc. Acuity denied that it had a duty to defend M.I. Homes under the policy and filed a declaratory judgment suit that was before the Court of Appeal. Acuity had issued to H&R a fairly standard commercial general liability and commercial excess liability policy. M.I. Homes was listed as an additional insured on the policy. In the underlying lawsuit, the Church Street Station Townhome Owners Association, by its board of directors, sued for breach of contract and breach of the implied warranty of habitability. In its amended complaint, the association sued M.I. Homes as the successor developer-seller for the townhomes, having succeeded to the entire remaining interest of the initial developer and seller, Newman Homes, Incorporated. The association alleged Newman and M.I. Homes constructed and sold townhomes with substantial exterior defects, including moisture-damaged or water-damaged fiberboard, water-damaged OSB sheathing, deteriorating and deteriorated brick veneer, poor condition of the weather-resistive barrier, improperly installed J-channel and flashing, and prematurely deteriorating support members below the balcony deck boards. The association further alleged that Newman and M.I. Homes did not perform the construction work themselves, but that all of the work on the townhomes was performed on their behalf by subcontractors and the designers. Basically a typical construction defect lawsuit. The association alleged also that the property damage was an accident in that M.I. Homes did not intend to cause the damage, material and construction defects in the townhomes, and the resulting property damage. The association claimed damage to other building materials such as windows and patio doors, including but not limited to water damage to the interior of units, and that the damages were neither expected nor intended from their standpoint. Acuity filed a declaratory judgment action against M.I. Homes and the association, although the association was not a party to the appeal. Acuity sought a declaration that it did not have a duty to defend or indemnify M.I. Homes. In turn, M.I. Homes filed a counterclaim against Acuity, seeking a declaration that Acuity did not owe it a duty to defend. The parties, as usual, filed cross motions for summary judgment, M.I. Homes argued in its cross motion for partial summary judgment that Acuity owed it a duty to defend because the complaint in the underlying action alleged that there were damage to other property, an allegation of damage beyond just repair and replacement of the construction work. According to M.I. Homes, property damage caused by an occurrence was therefore sufficiently alleged. The Circuit Court granted judgment in favor of Acuity and denied summary judgment in favor of M.I. Homes. The court, in its analysis, noted that the construction of an insurance policy and a determination of the rights and obligations thereunder are questions of law for the court which are appropriate subjects for disposition by way of summary judgment. The duty to defend is determined solely from the allegations of the complaint, and the duty to defend exists if the allegations in the underlying complaint fall within or potentially within the policy's coverage provisions, even if the allegations are legally groundless, false, or fraudulent. In Illinois, the insurer's duty to defend does not depend upon a sufficient suggestion of liability raised in the complaint. Instead, the insurer has the duty to defend unless the allegations of the underlying complaint demonstrate that the plaintiff in the underlying suit will not be able to prove the insured liable under any theory supported by the complaint without also proving facts that show the loss fell outside the coverage of the insurance policy. The policy, which is a fairly standard commercial general liability policy, raises the question of M.I. Homes' potential for coverage and Acuity's duty to defend that hinges on whether the underlying complaint alleges property damage caused by an occurrence. M.I. Homes contends that based on the association's allegations, the underlying complaint sufficiently alleged property damage caused by an occurrence. M.I. Homes also argued that this damage to other property was alleged to have been caused by an occurrence because the underlying complaint alleged the damage was an accident caused by the defective work of the subcontractor that was neither expected nor intended by M.I. Homes. Acuity argued that the allegations of damage to other property are not enough to trigger its duty to defend because the allegations are unconnected to a theory of recovery, and the underlying complaint failed to both identify the owner of the other property and explain how the association had standing to sue for the damage to that property. In Travelers Insurance Company versus Allege Manufacturing, a 2001 decision of the Illinois Supreme Court, the Supreme Court held that in determining whether there was CGL coverage, the predicate of property damage is satisfied only when property is altered in appearance, shape, color, or in other material dimension and does not take place upon the occurrence of an economic injury such as diminution in value. The Supreme Court in Elger also cautioned against expanding CGL coverage such that it functioned as a performance bond for the contractual work of the insured. Now, some of the cases in Illinois have noted that the other property requirement is not grounded in the policy language itself. As the court has acknowledged, this line of cases establishing an other property requirement has even been criticized by some commentators. The underlying complaint in this case contains allegations that could support an obligation to defend M.I. Homes. It alleges that the work of subcontractors and the designer caused damage to other portions of the townhomes that was not the work of those subcontractors. The association, as a common interest community association's board of manager or board of directors, by statute has standing and capacity to act in a representative capacity in relation to matters involving the common areas or more than one unit on behalf of the members or unit owners as their interests may appear. The court concluded that the threshold for finding a duty to defend is low, and any doubt regarding such duty is to be resolved in favor of the insured. Since the association clearly had standing to act in a representative capacity in relation to matters involving the common areas, the allegations of damage to other property can be a reference to the association's own property in the common areas, and there are no allegations that would clearly exclude coverage. Accordingly, the Court of Appeal decided that these allegations are enough to potentially fall within the policy's coverage requirement of property damage caused by an occurrence, and thus trigger a duty to defend. In my opinion, it has become almost impossible to refuse to defend an insured based on lack of standing or property damage to property not involved in the loss. In this case, the court found a duty to defend because there could be damage to the common property owned by the association. Unless an insurer can find clear and convincing evidence that there is no coverage for defense or indemnity, demands for defense should be resolved with an agreement to provide the defense under a reservation of rights, including the right to demand return of monies paid for that defense if it is later determined there was no coverage for indemnity. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone at zalma.com/blog. Please subscribe so you will not miss any blog posts. And if you found this video to be interesting or useful, please tell your friends and colleagues so that they can also subscribe to this blog and to my Substack publications and to my locals community. Thank you for your attention.